Hello and welcome to the Waite of the Law podcast. I'm here this episode with Harry Goulding, who is one of our solicitors in the family team. So Harry, how long have you been at the firm now?
So I trained here for 2 years from 2017 to 2019 and I qualified September 2019, so what was that, 6.5 years now, isn't it?
Gosh.
Mostly, the starting bit was all over COVID, which was fun. So,
that's true, yeah. That's gone very quickly though, hasn't it?
Definitely.
Yes, and during that time you've become a parent.
Yeah, recently.
And you're still smiling, that's good. And we all do a mixture of family law, don't we, in our team? But I think I think it's fair to say that you have developed a specialism.
I think it was more I ended up dealing with 2 very complicated cohabitation cases, and then that sort of has made me the de facto expert.
But we do defer quite a lot now to you, don't we, in terms of unmarried couples?
Yeah, I think that's probably fair to say. I think, well, one of the things I was interested in is it's one of the fastest growing sort of demographics, if that's the right word for it, in the country. So people getting married later or not getting married at all, or in later life having gone through a divorce, choosing to live together but not get remarried. And there's no sort of body of case law that's as big as the sort of divorce law that applies to cohabitation. So it's sort of an area that's rife for...
But I think the last however many years that I've been practicing, I think what we're still seeing is the surprise when we see new clients who aren't married and we have to break the news to them that there isn't a great deal of protection. So because I think there's still there's misunderstandings about what rights you have as a cohabitee.
Well, I think there's this sort of ongoing myth, I don't know where it really originates from, of common law marriage, of people who have lived together for a long, long time, and over time, eventually they just sort of get assumed to be married couples. And I'm not sure where that myth came from, but it is stuck around for a long time.
Yeah.
But yeah, there is no such thing as common law.
Yeah. And I think it's even harder when they've had children together, because obviously they think having children together gives them some additional protections.
Yeah. And I suppose you could argue that when they created, I mean, without getting too much detail, the Schedule 1 of the Children Act, the idea was they were kind of trying to create some additional financial protections for the primary carer.
But not to the level, I think, that...
But I think that it's not worked out quite how it was envisaged,
Yeah, in the same way that you would if you were a married couple and you separated.
Yeah.
So, and there's a difference between other countries as well. We sort of lag behind quite a few other countries, don't we, in terms of the protections.
I always wonder with that whether it might be because we're just a bit more locked in with traditions and we don't like the idea of, you know, it being a big growing demographic of cohabitation. Because
it's detracting from marriage,
yeah,
do you think? Maybe. It doesn't seem to be a high priority to change the law.
No, I think, well, amongst private practitioners, there's a pretty big push, but I don't think that it exists. The will is not there in government.
No. And I think Australia has very different laws, because I can't remember off the top of my head, but I think after 2 years, if you're cohabiting, you get certain protections in Australia. And in Scotland, you get certain protections.
Yeah, so I did a little bit of Googling actually just before we came to do this podcast. Don't hold myself out to be an expert in any country. Am I an expert in England? Certainly not in other countries. But there are some pretty interesting regimes in close neighbouring countries even to England. So Scotland has a regime where they don't apply divorce law, but rather than it being a sort of a principle of equal sharing like we would have in divorce, for cohabiting couples, they have this sort of compensation idea. So the case is the person seeking financial redress to prove. They're the ones who have to say, I've lost because of X, you know, I became the primary carer for 10 years or whatever else it was. But they can then seek a sort of bottom-up argument of saying, well, I need to have some sort of compensation to put me back in the position I would have been. So I think that's very interesting. It's sort of a halfway house. It's still on a very case-by-case basis. There's no formula. And then you can jump to the Nordic countries, and they've got a system which is much more formulaic, where they basically say if parties are not married and they separate, any joint assets, so the family home that they've both been using, any assets acquired for joint use, automatically split 50-50, but everything else that's outside of it is just retained separately. And again, I think that's quite interesting. And then just to cover it off, in the Netherlands, I read briefly, they've got a system where cohabiting couples are essentially not treated specially, but they have this option to register their relationship, and it's not then as formal as marriage, but it's a sort of halfway house again. And I think they also have a lot more, I don't know what, informed population about doing cohabitation agreements and putting things in a contract or whatever.
So I suppose that's something we should talk about as well, is what happens in this country if someone comes to see us and they say, I'm not married, we've been together for however many years, say 20 years, we've got 3 children. What would we say to them about their living arrangements and what they can actually do?
So the first thing we'll be doing is removing the sort of illusion of common law marriage, which I think for a lot of people is still a surprise. And then we'd be saying basically they are in the same legal regime that any people who own a joint asset together would be, and the sort of the cohabitation is not that relevant, except in some sort of types of arguments you can bring. But in terms of the law that applies, it's just standard law of property, which is you own things according to how you own them. And in theory, that's sort of the end of the story. I think that the courts or the law likes to make out that law of property is a very certain, there's not a lot of chinks in the armour, you can't really get many arguments going on that. I mean, cases have shown that there are a few more uncertainties than maybe the law would like there to be, but it's certainly more limited.
I suppose that's the other thing, is if it goes to court, if there's a dispute and the couple are not married and they go to court, under the property laws, it's usually heard by a judge that deals with family law, isn't it? You know.
Yeah, I mean, it's anyone's guess nowadays, isn't it? If you end up in court, it's just what judge do you get on the day. But yeah, certainly I think that historically there's been this sort of idea that cohabitation cases are this sort of halfway house between purely civil law and family law.
And I think it does depend on the judge, because I know a few years ago there were some judges that would try and use FDRs, which we use in financial proceedings when you've been married, in a similar way, but then it never really took off, and now we seem to have gone back to being much more about the civil procedure.
I think that's probably right. I think, I mean, there are 2 types of cases, I would say, generally when it comes to finances like this, which is cases where parties have all been very well behaved and have documented everything in advance, and it's all very clearly set out in some kind of express agreement. You get a big tick if you're in that sort of category. But then there are these other cases, and I think in that case, you know, you're looking at a much simpler set of litigation. There's much fewer things that can be sort of up for our dispute. And then there is a big other category, which is the ones where either because the parties never had a reason to get the documentation done, for example, if the properties were always only ever owned in one person's name, or if they just had bad advice at the time that they purchased things together, you're in this sort of much more nebulous world of various things that can be brought to bear to argue for.
So if someone came to you and said, you know, I've been living with my partner for however many years, but the property's in their name, but I have contributed, what happens then?
First of all, we would be saying to them, have you got any kind of documentation, even if it's not strictly legal, you know, any correspondence or letters or anything you might have informally drafted at the time when you started contributing? Normally the answer to that is no. And then the next thing will be sort of a bit more of a forensic exercise of looking back over the course of the relationship and trying to quantify what it is that they've contributed. Was it contribution towards the original purchase price? Is it contribution towards capital improvements? Those are both things which are going to be pretty helpful to their argument. If it's more small level stuff like contributing towards bills or a small amount of rent that they've paid regularly each month to the other party and it's all sort of pre-proportionate, they're going to have a much tougher time. Where cohabitation does become more relevant, and I said at the start that, you know, it's not necessarily any different to any other two people who own property together, is that there is this kind of understanding that it's less, if two people who were not cohabiting and were arm's length parties owned a property together, and one of them suddenly had a case that was basically, oh, the other person has decided to just gift me a 25% interest in the property, I think a lot of people would look at that and say, well, where's the benefit to them? It's a bit more of a sort of commercial relationship. In cohabiting situations, there is a bit more of this sort of argument where you can say, oh, we treated everything jointly, although we weren't married, we kind of acted like we were. And then it's much easier to try and get off the ground these arguments that there was just this sort of ad hoc gift from one person to the other, without necessarily there being finances flowing in the other direction. But you would still need there to be the sort of explicit gift.
What if somebody has said to so the property's in one person's name and they've said to the other party, you know, don't worry, this will always be your home. I see it as a jointly owned property, even though it's in my sole name.
So it's interesting. I mean, when we're dealing with these cases, the best case scenario is you're always trying to look for some kind of actual financial contribution.
Yeah.
And that's where you're grounding your argument. Those are much more sort of tried and tested arguments. There is this sort of plan B type argument which you can fall back on, which is this kind of what we would call an equitable remedy. So it's not prescribed anywhere in kind of statute or anything like that. It's a remedy that has grown up over the sort of long tradition of English courts of kind of trying to say, well, there's something unfair going on here, and trying to sort of put it to right. And that, I mean, there's a legal name for it, it's proprietary estoppel, and it's the idea that one person has sort of made promises which they're now reneging on, and the other person has sort of relied on that somehow to their detriment. I mean, it is uncommon to run an argument exclusively on that, and I don't think we would be very confident about telling the client to do it, but certainly if you were running an argument on some other ground, you might throw a proprietary estoppel claim in. And most of the proprietary estoppel claims tend to be over these very long periods where parties have been together, and normally there's been some kind of other element to it, like classic is farming cases where someone has sort of lived on the farm, worked on the farm for no wage, long-term detrimental reliance in belief that they had an interest in the property, and then they separate and they're told to get out, leave the farm, and they have nothing to show for their 20 years of work. I mean, those are sort of, they're less common, but you can always try it. Yeah.
And so then I suppose what we need to be talking to people about is what can they do to stop themselves from being in that position. And you were saying about how, you know, documentary evidence, the title to the property is the key, but if your name for any reason isn't on the property, then there are other documents that you can
absolutely. I mean, what the gold standard of what we're looking for is some sort of signed express declaration, ideally signed even as a deed, and recording on the face of it what the parties intend, you know, in a relatively clear way, whether it's just percentage split or, you know, someone getting a certain lump sum out and then the remainder percentage split, whatever it is, but having that recorded in a legal document, that sort of is pretty close to ironclad if you get that done properly. And certainly if parties are buying properties together, conveyancers should at the time be advising them to consider this. What I would say is, I think different conveyancers deal with that differently, and there doesn't seem to yet be a sort of common standard approach that's taken by the advice conveyancers will give, and generally they want to deal with the properties, the sort of the purchase stuff, rather than dealing with how their two clients are going to sort things out financially.
I think as well, conveyancers aren't litigators, are they? So they're not thinking of what might happen in the future.
How it could go wrong, which we
obviously because we're dealing with that. That's something we're very aware of.
So what I would say is, for people doing that, don't necessarily just rely on conveyancers. The conveyancer will hopefully signpost you, but if you're going to be putting in a lot of money and you're going to be living together long term as cohabiting couples, get the documentation sorted at the outset. If the case is different and it's not the case that you're buying a property together, but say you've met and one of you already owns a property, those are actually the cases where I think it's more likely that issues are going to arise, because there won't be a sort of trigger that gets you to go and actually do put the paperwork in place. If you just start living with them at their property and slowly you start becoming more and more financially involved, And I think the only thing we can say to them is just be aware of it. And if you're going to start having significant capital outlay, always assume, if you're the person who's not legally on the property title, assume I might be walking away from this with nothing.
You're potentially going to lose that money.
Would you be happy to pay the money if you knew you were going to lose it?
Yeah.
And maybe if it's a few £100s, you'll say yes. And if you're getting into the tens of thousands, you're going to be saying no way.
Yeah.
So.
Yeah. And I think there's the added complication as well into this day and age, because it is so hard to get on the property ladder, that often family members, parents or grandparents will have gifted or there's a bit of a grey area suddenly whether it's a gift or a loan, but given money to their
I mean, you can get into sort of
grandchild.
exam style questions where it's sort of every complexity you can think of, and then they've done works to the property after they've purchased it, different family members have contributed what, none of it's documented. It can get, because it's so analytical and we can't sort of fall back on what family lawyers love to do in divorce cases of kind of, well, it's all very broad brush, we're not going to get too forensic. You do actually have to try and conduct quite a forensic exercise and sort of work through from first principles, which obviously can become quite expensive, particularly if you get experts involved or whatever. And I think it comes down to it again, if family members are going to be putting money in, they should want to be documenting what it is they're doing as well. And if not, again, the presumption probably is going to be, well, if it's not documented and it's just been gifted, that it's an advance on inheritance and it's going to be treated as a gift.
And it could be lost down the line.
Exactly.
And what are your views on cohabitation agreements?
Well, I think if parties are not getting married, I mean, there's lots of reasons parties choose not to get married in this day and age, but one of them, I think, is having greater autonomy and control over their finances and sort of taking decisions intentionally as a couple, and that is what cohabitation agreements are. They are a very certain agreement. I'm pretty pro them. If parties are going to be living together long term, they're not getting married, I think it is sort of the gold standard again.
It takes away any potential shocks in the future, because everyone's had a discussion, or they should have had a discussion if they're entering into a cohabitation agreement about what. And I think so
much of legal documentation like this, particularly when it's done in advance, is as much as providing the legal protection, it's about making sure everyone's on the same page as well. And if everyone is on the same page, hopefully you don't really need that much legal input once the agreement is signed, because parties can kind of, they know what they're to expect from it anyway. And that sort of is the spirit of these sorts of agreements. You agree them when everyone's still friendly, and hopefully everyone lives accordingly and plans accordingly.
And I think I've potentially mentioned on the podcast before, having something like a cohabitation agreement or a declaration of trust, it's like having an insurance policy, but instead of paying out monthly, you have to pay out at the beginning. But it gives you that sense of you've got some sort of insurance because it's documented.
And the costs of getting a cohabitation agreement, even if you went to some very expensive lawyers, in central London or something like that, is going to be insignificant. Well, it's going to be a fraction of the cost of even mild litigation at the other end, because litigation is where costs really rack up on a.
And I think that's the other point, isn't it? That the litigation that you would get involved in under the civil procedure as an unmarried couple can often be actually more expensive than.
Certainly it's much more front-loaded than divorce litigation. In divorce litigation, the whole emphasis from the courts is to try and get parties sort of settling by themselves, and they sort of try and push back as much as possible any of the real heavy-hitting costs until you need a final hearing, basically. So if you settle early on in those cases, you save yourself a whole chunk of costs. In civil procedure, it's much more front-loaded. You will incur a lot of cost up front to sort of make sure you've formally pled your case properly. It is a lot less forgiving as a procedure than family procedures are, so you want to get it right from the outset. You don't really get so many chances to sort of tweak your case or what you're arguing for.
And you're more likely to get a cost order against you if you've got it wrong, which is less likely in the family courts. So it's if you can avoid that type of litigation by having a declaration of trust, by having a cohabitation agreement, by having those conversations, it's well worth it.
I think from a stress point of view as much as anything else, I think most lawyers would say civil litigation is slightly more, because it's more high stakes because of the costs orders. It's more stressful for the lawyers as well, but if it's stressful for the lawyers, it's definitely more stressful for the clients. And I think, proportionately as well in divorce, even if your costs are relatively high, you're arguing over what is ultimately the entire financial estate. Whereas in these sorts of cases, these civil cases, you're ultimately limited to arguments about just the property, and that means that the costs are inherently going to be less proportionate because it's a smaller pie that you're arguing over.
Yeah. Thank you for joining me, Harry, and we'll see you in the next episode.